The battle for birthright citizenship, a Supreme Court showdown. The Trump administration's controversial attempt to redefine birthright citizenship in the United States has ignited a fierce legal battle, culminating in a direct appeal to the Supreme Court. At the heart of this conflict lies a stark clash between executive power and judicial review, a fundamental pillar of American democracy. The stakes are incredibly high, impacting not only the lives of countless individuals, but also the very fabric of American immigration policy and the constitutional interpretation of the 14th Amendment. The saga began with an executive order issued by the Trump administration, aiming to drastically alter the long-standing principle of birthright citizenship, enshrined in the 14th Amendment Citizenship Clause. This order sought to restrict citizenship for children born in the United States to parents who are not lawful permanent residents or American citizens. The target: children born to unauthorized immigrants and those holding temporary immigration statuses. The order didn't merely aim to deny citizenship. It also prohibited federal agencies from issuing or acknowledging documentation confirming citizenship for these children. This bold move immediately sparked a wave of legal challenges. 8 lawsuits were filed, effectively halting the implementation of the executive order nationwide through a series of nationwide injunctions issued by district courts. These injunctions, issued by judges in Massachusetts, Maryland, and Washington, represented a significant roadblock for the Trump administration's ambitious plan. Now, the administration is appealing directly to the highest court in the land, seeking to overturn these lower court rulings and pave the way for its controversial policy. Acting Solicitor General Sarah Harris, representing the Department of Justice, has filed an urgent request with the Supreme Court, arguing that the lower court injunctions represent an unwarranted overreach, hindering the executive branch's ability to implement its policies. In her filing, Harris underscored the far-reaching implications of the injunctions, stating they micromanage the internal operations of the executive branch, preventing not only the enforcement of the citizenship order, but also the internal steps necessary for its implementation. This assertion directly challenges the authority of the judiciary to intervene in the executive's internal processes, raising complex questions about the separation of powers and the limits of judicial review. The administration's argument centers on the idea that the executive branch holds the sole authority to interpret and implement its own policies, free from undue judicial interference. The unprecedented nature of the executive order, a significant departure from established practices, is downplayed in this argument, emphasizing instead the executive's inherent right to enact and enforce its vision for immigration policy. However, the lower courts saw things quite differently. In a key ruling, a federal appeals court in San Francisco rejected the administration's attempt to reinstate the birthright citizenship restrictions. Judge Danielle Forrest, in a carefully worded opinion, highlighted the routine nature of legal challenges to both executive and legislative policies, particularly when those policies represent a radical shift from established norms and precedents. This ruling underscored the judiciary's role as a crucial check on executive power, safeguarding against potentially unconstitutional or overly broad policy implementations. The case before the Supreme Court presents a profound constitutional question. Does the executive branch possess the unfettered authority to unilaterally redefine birthright citizenship, a cornerstone of American law since the ratification of the 14th Amendment? Or does the judiciary have the right, and perhaps the obligation, to scrutinize such sweeping changes, ensuring they comply with the Constitution and established legal precedents? The implications extend far beyond the immediate legal battle. A Supreme Court ruling in favor of the administration could dramatically alter the landscape of American immigration, potentially impacting millions of children born in the United States to undocumented parents. Conversely, an affirmation of the lower court rulings would reinforce the judiciary's role as a protector of constitutional rights and established legal principles, limiting the scope of executive power in this sensitive area. This is not simply a legal dispute. It's a fundamental clash over the interpretation of the Constitution, the balance of power between the branches of government, and the future of birthright citizenship in the United States. The Supreme Court's decision will undoubtedly shape immigration policy for years to come, leaving an indelible mark on the American legal and political landscape. The eyes of the nation, and indeed the world, are keenly focused on the justices as they grapple with this momentous case, the outcome of which will have profound and lasting consequences. The weight of history, the principles of constitutional law, and the future of countless individuals hang in the balance. This is a battle for the very definition of American citizenship, a battle fought not only in courtrooms but in the hearts and minds of the nation. The Supreme Court's decision will not merely resolve a legal dispute, it will shape the narrative of American identity for generations to come. The wait for a resolution is agonizing, but the stakes are undeniably monumental.